This case involves Duško Tadic, a Bosnian Serb politician who was charged with crimes against humanity, grave breaches of the Geneva Conventions concerning Articles 2, 3, 5, and 7, and violations of the customs of war. The International Criminal Tribunal for the former Yugoslavia tried him for his actions in the Prosecutor region, including several concentration camps. Tadic went on trial in 1997 and was the first to be tried by an International Criminal Court of War since the Nuremberg trials in 1947. During the Bosnia War from 1992 to 1995, Tadic was an active member of the SDS party who pursued a campaign of ethnic cleansing within the former Yugoslavia. Tadic was actively accused of being involved in the ill treatment of Muslims and Croats living in Yugoslavia, as well as attacks against civilians in the district of Prosecutor. Tadic was arrested in Munich in February 1994, and he was later tried by the ICTY, where he was found guilty on 9 counts and partially guilty on 2 others. Tadic and the prosecution appealed this hearing on a number of grounds, giving birth to the case Prosecutor v. Tadic. Tadic challenged the court in 3 different ways. First and foremost, Tadic argued that the United Nations Security Council did not have the power to create the ICTY. Why? Being an executive branch of the United Nations, Tadic claimed that the Security Council did not have the power to create a separate judicial body. Thus, the ICTY was illegitimate and should not exist, let alone prosecute. In turn, the UNSC had to prove that the Security Council had the legitimate authority to establish the court. It argued that according to Chapters 6 and 7 of the United Nations Charter, the Security Council was allowed to deal with all matters of international peace and security, however it deemed fit. Tadic appealed this ruling again, proposing his second argument. He claimed that the ICTY was violating his rights to have a trial in a national court on the basis that national courts should have primacy over international tribunals. The court refuted this argument on the basis of Article 9 of the ICTY statute, which asserts that the International Tribunal shall have primacy over national courts. Furthermore, Tadic's personal rights could not have been violated, given that Bosnia and Germany both gave consent to the tribunal to prosecute him. Number 3. Tadic proceeded to make his final and most important claim that the ICTY did not have legitimate jurisdiction over prosecuting war criminals. He claimed was that the ICTY did not have ratione materi, or subject matter jurisdiction. Essentially, he contended that the crimes he committed were in a state of war and not of an international nature. In turn, the court was faced with the challenge of determining whether or not the ICTY itself was a legitimate body created by a legitimate means. Firstly, the court had to determine whether this was an issue of jurisdiction or not. Because jurisdiction wasn't narrowly defined in an international context, it determined that jurisdiction was indeed the issue at hand. In addition, the court held that for the International Tribunal to be created according to the rule of law, it has to be established in accordance with the proper international standards. These standards include a guarantee of fairness, even-handedness, justice, and in full conformity with internationally recognized human rights instruments. Because the ICTY followed this framework, the court concluded that it did have legitimate jurisdiction to prosecute Tadic. This case had many important implications. Firstly, it legitimized the establishment of the International Tribunal by judicially upholding the authority of the Security Council to establish ad hoc judicial bodies that assist in sustaining international peace and security. Not only this, but the case became influential in the development of humanitarian law and became a precedent for future cases, as well as the development of the International Criminal Tribunal for Rwanda. Although Tadic was released in 2008 and now walks the streets of Serbia, this case sets important precedents in international law. 5 points for effort.